Ladies and gentlemen, welcome back to another episode of Letters of Intent. I am your co-host, Pankaj Raval, and I am joined today by my trusted co-host and corporate attorney here at Carbon Law Group, Sahil Chowdhury. Sahil, how are you today?
I'm doing great. And today we want to welcome our whole carbon community to another episode of Letters of Intent, the podcast for deal makers and risk takers. And today we
Absolutely.
welcome you to our weekly show where we break down the biggest headlines in deal making and how they apply to you. So I want to give you the rundown. Our first story centers on Taylor Swift getting sued over the name of her album. And the trademark lesson here will apply to every brand name, product line, and logo that you own. The second story we're going to cover will be Elon Musk is about to pull off a $3.4 trillion merger. I know all eyes are on this merger, but there is a legal trap buried inside it that many founders, even in the private markets, can fall prey to. And how this ends will decide whether your content is an asset that you license or just free training data for someone else. So, Pankaj, let's start with IP and kick things off with Taylor Swift's Showgirl trademark fight. What do we need to know?
There we go. Taylor Swift in the news again. She is a savvy business person, but no matter how big she is, no matter how big you are, you cannot escape the law when it comes to IP and trademarks. And this is just an example of that. So this is another situation where we see a famous company, a famous artist want to use a mark that may have some issues. So we don't know how much of a search she did, how much of analysis they did before they file this trademark. Generally speaking, when people hire us to file a trademark, we're going to do a search and analysis report. We're going to cite possible conflicts and discuss the risks for clients going forward. However, in the world of business and art, sometimes you got to move forward even if there are risks. And I think that probably is what they decided to do here, because the plaintiff has had this trademark since 2015. And the trademark at issue here is called Confessions of a Showgirl. So Taylor Swift has the trademark, or is filed for the trademark, Life of a Showgirl. And we have this person, Marin Flag, who filed a trademark in 2015 for Confessions of a Showgirl. So I'll leave it to you guys to think, okay, are these confusingly similar? They both are artists. They both have acts that kind of go on the road. So do you feel like there could be confusion here? I think there's a strong argument that says that Taylor Swift is very much her own brand. And this is probably maybe a sub-brand of Taylor Swift. But when it comes to trademark law, it's not that simple. And there's an injunction that's been filed to try to stop Taylor Swift's use of the mark and probably also ask for damages. However, that is being fiercely opposed by Taylor Swift's legal team. And I have a feeling this is not going to be resolved anytime soon unless there's some kind of settlement to have this kind of just go away. But there may be a payout here for a flag. So it shows you that, hey, even if you're a small fish in this big sea, no matter what, your trademarks really could have significant value. If there happens to be a famous person, a billionaire, someone who comes along and likes your trademark, you could still have some very significant value here in your mark because it is an asset and it is so essentially a property right. So you want to think about that when you're filing your trademarks, and it is definitely better to have that trademark protection there.
And that's where Wade's argument comes in. She's actually arguing reverse confusion. She's saying,
Right.
Swift is so big that people are going to think that she came up with the idea for this Showgirl name, when in reality, Wade has actually registered the mark in 2015.
Right.
And so
Exactly.
Swift's argument here centers around this concept of an expressive work to try to kind of skirt around the registered trademark. What does that mean? What is an expressive work?
Yeah, so it's kind of like a nuance between copyright and trademark that people use to argue that the name itself doesn't fall under certain protections of trademark law. Here, Swift is arguing that the title of her work, the title of her album, can get First Amendment protection under something called the Rogers test. And that means the work is protected if the title has artistic relevance or isn't explicitly misleading. And that's the shield she's trying to use right now. She's trying to say that, hey, this has some relevance to what she's doing. There's an artistic element here. It's a single title. And single titles of works are generally not entitled to trademark protection. You can get trademark protections for like series of works. For example, the Harry Potter series has trademark protection, but if it's a single book, you're generally not going to have trademark protection there. I think that's the argument they're making. But that doesn't necessarily get them around some of the trademark issues, though, too. So I think, yes, it does protect them in certain elements when it comes to protecting the work, but it doesn't, I think, protect them in all capacities here. So I think it is an interesting argument, but I don't know if it's going to get them across the finish line.
Yeah, we've got The Life of a Showgirl is Taylor Swift's album, and Confessions of a Showgirl is Wade's trademark. So
Right.
the question is, if Swift is going to have this album, merch, is going to be leveraging this name, does that bleed into people getting confused over the origin of Wade's mark. And how should a founder really be thinking about this in terms of the way a court will evaluate this? What's the most important test here? Is it a test related to confusion and confusion in the marketplace?
Yeah, so when we're looking at trademark law, that's really one of the primary tests we look at when we are evaluating trademarks. And the test that the courts apply is called likelihood of confusion. And likelihood of confusion is comprised of 13 different factors according to the DuPont test from the Supreme Court, which is the Supreme Court analysis of how trademark confusion works, or you have Sleekcraft, which is in the Ninth Circuit. So those are about this 9 factors. So it really just kind of depends where you are. The different circuits will have different tests applied, but fundamentally the questions are very similar. There's 13 in the DuPont because some of them are separated, while Sleekcraft seem to combine some of these questions into one question. So, but fundamentally you're looking at, okay, how similar are the goods? How similar are the trade channels? How similar are the consumers? How similar are the marks? What is their commercial impression? You're going to look at the construction of the marks. You're going to have to look at phonetics. Are they phonetically equivalent? Is there other uses of the mark out there? You're looking at sophistication. There's a lot of different factors you're going to look at for trademark analysis when you're looking at likelihood of confusion. And that's really the main test. And to determine whether something is confusing is not exactly easy or cheap. Oftentimes in trademark litigation, we'll have to hire an expert or hire a company that does a survey and actually go out there and get these surveys done. And they're very expensive to do, to figure out, okay, are these marks actually confusing? Does a consumer that's relevant to your market find these marks confusing? And that's a big question. And here, again, the question is not so much about just likelihood of confusion, but it's also reverse confusion. Oftentimes likelihood of confusion is, okay, when two marks are similar, when the size of the companies are similar, we look at likelihood of confusion. Here, Taylor Swift is obviously such a massive global phenomena. She's assumed a mark that is causing what the plaintiff is saying, reverse confusion. That means that the little guy is being harmed by this big player flooding the market with their use of the term, and is now causing consumers to associate that term with them instead of the plaintiff, who actually had this mark for the longest time. So what you want to think about when you're registering a mark is, do you have the priority, and is your mark distinctive enough? And what we always say is, like, using it first commercially is best, but also making sure that your mark is distinctive. That means looking at the likelihood of confusion test. So those are the two things you really want to think about fundamentally, but there's obviously a lot more to it as well.
All right, Bunkers, this brings us to our second segment, Musk's Tesla SpaceX merger. This is, as we all know by now, a merger that is on the horizon, and it is going to be the largest in history. We've already seen Elon Musk play chess with his own companies. XAI was already folded into SpaceX in February. So a Tesla SpaceX combo is going to put cars, rockets, Starlink, and XAI under one roof. This is massive scale. We're talking about a combined entity that has a value of $3.4 trillion, anchored by a potential SpaceX IPO valuation near $1.75 trillion.
It's a lot of zeros.
This is huge. And it would also be a giant that is currently burning cash. Not the first time we've seen that. Amazon was also burning cash pre-IPO. Tesla guided to negative free cash flow. Tesla is anticipated to have negative free cash flow for the rest of 2026, amid a greater than $25 billion capex. Tesla has already put $2.2 billion of equity into SpaceX. They're partnering on the largest U.S. chip fab at Gigafactory, Texas. And Tesla booked $430.1 million from XAI and $143.3 million from SpaceX in 2025. We've seen a lot of commentators ranging from Scott Galloway to even the Poly Market and Kalshi markets who are kind of cooling on this IPO. Now, what's interesting here for us from a corporate governance perspective is that Musk is on both sides of the table. He controls the buyer and the seller. Now, this is a structure we actually deal with regularly. We do Section 351 mergers. There are often stock for stock transactions where a merger is occurring that's for the benefit of a reorganization or a restructuring, but you have one individual who's the primary owner of each entity. So you have a lot of fiduciary duties here. And as we know, directors owe fiduciary duties of care and loyalty. You have to protect the other members of your cap table. And a conflicted deal can flip the court standard from the deferential business judgment rule to an entire fairness rule. And the company must prove both a fair price and a fair process. This is, if you have heard your lawyer or your CPA talk about a 409A valuation, that's where this comes into. You want to have a fair market valuation at multiple stages of your company. That comes into play when it comes to fairness, fiduciary duty, the IRS. You can't just say your shares are what you think they are. You actually have to have some basis for that. And that goes into fairness, and specifically fairness towards your other investors. There are ways that this is going to be de-risked. There will most likely be a special committee of independent directors, an independent banker's fairness opinion, genuine arm's length negotiation, and a majority of the minority shareholder vote. In Delaware, if we do both up front, then we're able to restore that lower threshold of business judgment as opposed to an entire fairness consideration. Now, there's a major risk here, which is key man concentration risk. This entity is going to be hugely dependent on one person. That's a governance and disclosure risk that's going to have to be disclosed to the investors. We're also looking at a potential regulatory wall, combining a public automaker with a defense adjacent rocket company. That is definitely going to invite some antitrust and national security review. Okay, well, this is the largest IPO in history and it doesn't involve you. So why are we talking about it? Because it does apply to you. There are many different ways that you can restructure your companies when you are also involved in a deal where there are related parties, where let's say you're the primary owner of two companies, or the parties are just related in some other way where there might be a potential conflict of interest. You still can structure a holdco structure. This is applicable, especially when you've got private equity roll-ups. You're rolling up your companies and basketing them, bundling them up to be sold to a private equity company. And then also you have internal reorganizations and you need to keep your options open. And often there are conflicts of interest in those transactions. So even though there are smaller zeros behind those deals, it's the same rules. So remember to build the record. We're talking about independent valuations, like we were talking about 409A valuations, document arm's length terms and transactions. So let's say you're a contractor for one of your companies in which you hold a majority. Make sure you're keeping track of your board minutes. That's also essential for you to protect against the piercing of the corporate veil. And make sure you're showing real independent review. This is where having independent directors comes into play. If you have board approvals that reflect independent judgment, that's going to help you when it comes to building your record against conflicted transactions. Your paper trail is your defense. And if minority investors want to assert any allegations against you in terms of breaching your fiduciary duties, you want to be able to show that you actually been playing by the rules and that you are operating with some semblance of independent judgment. You also want to make sure you're policing your intercompany agreements. We're talking about IP licenses, shared services, transfer pricing between your entities. We know that that happens often where you might have a company servicing one of your other companies, but they need to be on market terms. We see this often with management services organizations and professional corporations. Make sure you're engaging on terms that are fair market value, and that way you can protect your minority shareholders. Now, there's a secret weapon at your disposal, which is called the F reorg. And this is a clean way that most founders will insert a holding company before a deal. But it is very complicated and it deserves its own episode. So we're going to save that for the next episode. There is a lot to learn from this deal. And so we want you to take a look at this, not just because of the size and scale and kind of look at it as something distant and far away. We want you to pull some very important corporate governance rules and lessons from this deal.
No, I think I agree. Sahil, yeah, it's a great recap because I think also we don't want to gloss over the fact that he's poised to become our first trillionaire, you know?
That's
And
right.
what does that mean in the context of capitalism and our economy? Do we want more trillionaires out there? Is that good? Is that bad? I'll let you guys think about that. When someone has $1 trillion, but then the average person is making $29,000 a year, is that a just society? Is a big question. But ethical, moral issues aside, Elon Musk has created a lot of value for a lot of people. And I think love him or hate him or ambivalent about him, whatever, however you feel, he has really taken some big swings. And this is another big swing that he's taking. And he's managed to like gather enough cachet behind his brand and who he is and what he's been able to do with these companies, with Tesla and everything else. And he's made a lot of false promises. He's made a lot of misstatements over the years, but apparently that's allowed him to do well. So
Great
yeah,
point. That's in the context of negative cash flow.
yeah,
It is surprising. It's going to make him the world's first trillionaire. It also shows the power of capital in the sense that a lot of these projects wouldn't be possible without aggregating capital in this way and
yeah.
organizing it in this way. He's talking about colonizing the interplanetary system. He's talking about AI. It's also interesting. We talked about this in our last episode about how he lost his battle against OpenAI. And yet at the same time, he's winning here.
Yeah.
He's about to become the first trillionaire. And the other thing that I've heard him say is that his belief that money eventually will become meaningless, which is kind of a shocking statement from someone who's
Yeah,
about to
it's a
become the
trillionaire.
world's first.
Easy to say that. Easy to say
Yeah.
that when you're a trillionaire.
It's easy to say money doesn't buy happiness when you're the world's first trillionaire.
Yeah, I think it's probably very easy to lose perspective, and we'll see. And I think it's true also about money buying happiness because I feel like he's got a lot of issues to deal with still as he navigates this crazy world that he's stepping into. But I think you're right. I think one thing I think for all the listeners out there, if you want to play, I think these highest levels and what we see for our bigger clients, it's access to capital, right? A lot of these businesses, especially the larger tech businesses, they survive on capital and leverage to get to the next level and try to beat out all the competitors. At this level, they're just trying to spend as much as possible to outspend and outgrow their competitors as quickly as possible. And it shows you like it's a different world that they're living in. But if you want to play in that world, I think you've got to understand capital. And funny enough, if you look at a lot of the CEOs, Jeff Bezos, and many others came from investment banking. If you look at the number of CEOs that actually are investment bankers or have some connection to investment banking, it's pretty high. And I believe that is because they understand how capital works and how leverage works. And I think that's the name of the game here.
That's a great point. When we look at valuations, valuation is something that gives you a multiple debt. And so I think the companies that we've seen do very well, even amongst our clients, are the ones that understand how that capital multiplies, how you
Yeah,
take something that is valued today, but you are actually building towards a future that has a multiple of your current share price. And even understanding how that's going to serve you to accomplish projects that you cannot do alone. I think a lot of small businesses start off as a shop or as a small software company, and you are operating on a business model that relies on you, that relies on your product, that relies on a specific margin. But what we've seen is the companies that really scale and grow, they're generally associated with founders who understand capital and the multiplication effect of that capital.
absolutely. So, Sal, with that, let's pivot. And before we pivot to segment three, I did want to give a little shout out to a basketball event that Carbon Law Group has been sponsoring called Founder Basketball. If you play basketball, if you're interested in playing basketball, if you're a founder, if you're building a company, entrepreneur, then this could be a great event for you. We're hosting two more events in LA. The next one, I believe, is July 17th, around that date. And we last one was in downtown LA. And it was a lot of fun, a lot of great founders, a lot of great companies featured their products. And we got together and played basketball and got to know each other. And it was a really fun event. So if this is something that you'd be interested in, we'll be sending out information on our newsletter. We'll post a link to sign up for our newsletter in our show notes, or you can always reach out to us and ask for that information. We'll be happy to send it to you. But it's called Founders Basketball, and they're on Instagram as well as LinkedIn. So we encourage you to look out for that if that's of interest.
Bunkers, I think we're going to need to see some content of that on the Carbon Law Group Instagram account.
I think we need, yes, we need to get more of
Is
that out there.
there, I mean, I heard you played.
Yeah,
I heard,
I
I heard you
played. I
do
played
ball.
decently well.
I
Yeah, I
heard
played
you do
decently well.
ball.
Scored probably 3 to 5 points of the games. Yeah, so each game. So the games were 10. So yeah, I mean, my shot was dropping that day. You know, I felt good. I felt good.
Forget about the NBA finals. You want to plug into the Founders Basketball League and you
Yeah,
want to plug into Carbon Law Group.
exactly.
We're taking it home. We've got our team captain here. So make sure that you connect on that if you love to play basketball or you just want to meet founders and you love business.
Yeah, absolutely. Not everyone there was playing. A lot of people were just kind of talking to people on the sidelines and getting to know the different brands that are featuring their products there. A lot of really cool brands. There was like a protein ice cream brand. There was a special like popcorn brand. There was a kind of fizzy wine brand. So yeah, a lot of really cool brands there too. So if you have any interest, please reach out and we'll happy to pass on information. With that said, we're pivoting into segment three. We're bringing it home with another shot fired in the world of AI and content partners. So today we're reporting that CNN has filed a lawsuit against Perplexity. Perplexity, if you guys are not aware, is similar to ChatGPT, but is more of like a wrapper for ChatGPT and Claude, but it provides its own kind of news aggregating service. It does a really good job of kind of searching the web and providing unique resources. It's a multi-billion-dollar company. And just as OpenAI is being sued by the New York Times, CNN is suing Perplexity because it allegedly scraped 17,000 plus CNN stories, videos, and images to power its answer engine, delivering identical or substantially similar competing content in real time. So, Sahil, this is comprised of two claims, not one. So, copyright infringement and trademark infringement. CNN says Perplexity falsely implied an active content relationship with CNN in its advertising. However, that didn't happen. CNN's first lawsuit against the AI company, and believed to be the first in any TV network by any TV network, CNN says it tried to license to Perplexity last year and the talks failed. So then what happened? Perplexity went ahead and did it themselves without even getting the license. And that's the rub here. Perplexity's defense is that they said that you can't copyright facts. And this is a defense we see all the time, especially when it comes to data. However, while you can't copyright facts, you can copyright the aggregation of facts, how they're displayed, how they're presented. And I'm sure that's what CNN is going to be claiming here. It definitely sounds like Perplexity's in the wrong here, but we'll have to see how this all fleshes out. Most likely there will be a settlement because Perplexity is going to be forced to probably license the work that it took without the proper license. It's not a good look when they enter into licensing talks, those licenses fail, and then they go ahead and they try to go around the company and use the data anyway. So,
So
yeah, go ahead.
Perplexity is claiming fair use here. What does that mean? And does that apply?
Yeah, so fair use, essentially, there's four factors. And when you're looking at fair use, you have to look at like the nature and extent of the use, how it's being used. Is it commercial or non-commercial? Is it educational? Is it newsworthy? So I haven't read their entire response here, but they could argue that, yeah, there's newsworthy information that they're commenting on it. But I think they fail with the fair use argument because they are using this in a commercial purpose. They're making money off it, right? If you're making this much money off it, generally the law says that, okay, yeah, if you're making money, you should be able to pay a license. You should pay a royalty for using this information. And it's not just for educational or newsworthy purposes. You're generating money and therefore you should pay the license fee or get the rights. So I have a feeling that CNN is going to be in the right. CNN's got so much content that it is really valuable. And I'm sure that's what Perplexity wanted to use, but they spend a lot of money on that content. So why shouldn't they be able to charge for it and get a fair royalty for it? So we'll have to see what happens, but this is not the only case out there we see of a content aggregator or content provider, content creator, news service, whether it be video or publication, suing an AI company for illegally scraping its data.
There is a bad fact in here for Perplexity, which is that CNN actually did try to negotiate for a license with Perplexity, and Perplexity declined.
Right.
And then CNN says, well, Perplexity just kept scraping. And once you've said no, the continued use does look willful. So I think
Exactly.
that fact is going to emerge and play a role in the actual analysis.
Yeah, exactly. And I think if you're a smaller company and you do have a lot of data, so I think there's two takeaways here too from this, Sahil, is that if you are creating content, if you're creating unique content that is valuable, you want to think about how you can leverage that in the future, right? If you are creating something new and unique and providing unique insights on what's going on in the world, AI companies are going to be interested in that, and you could have a potential to license that content. So that's something you want to think about as a content creator, content developer, news aggregator. If you have unique data, think about how you can leverage that in many different ways now and potentially have enter into multiple license agreements with different entities to make the most from the content you're creating. And two is that if you are going up against one of these companies, recognize that they may in fact do what they want anyways. And then are you going to have the wherewithal to sue them, to go after them for using your data? So maybe it's better to have a deal where you get 70% of what you want rather than 100% and having to fight. And they probably know that too. And it's an unfortunate fact, but something to keep in mind.
Yeah, I'm thinking we are on the cusp of a lot of legal battles when it comes to who owns what with AI. This standard of if it's human expression, it's copyrightable. If it's not, then that it's not. That is still a very blurry line. And I'm pretty concerned that there are going to be a lot of startups that use a lot of third party data through AI, and that's the moat, and that's not a real moat. I think
Right.
that we're going to see a lot more court cases that are going to further define what the line is, but there's going to be some collateral damage. There are going to be some companies that go all in on content coming from AI and they're going to get hurt in the process, but there are going to be courts that are going to come in and say, well, actually, you don't own that data. You can't monetize that data. You can monetize part of it, but you can't monetize for example, the expression that's coming from somebody else. And yet today, I think people are increasingly moving away from primary sources and they're going to ChatGPT, they're going to Claude, and they're just asking for the answer. Hey, what happened between Iran and Israel today? What happened with Trump today? What happened in the markets today? And I think very few people, or not very few, but increasingly you're going to see that over people surveying and reading primary sources, which is probably what CNN is worried about. It's like,
Right.
hey, wait a second. Is anybody going to be coming to my website anymore? Or am I
Right.
forced to now plug my data in through one of these funnels, one of these AI platforms?
Right. Exactly. Exactly. Yeah. So yeah, let's tie this all together, Sahil. So yeah, we got three distinct stories, but I think there's one common theme and help us understand what does this make sense for small businesses and scaling companies?
Bunkage, I think here's the lesson. what you own matters, and you need to paper that. We look at Taylor Swift. This could have been solved by her team doing a search for Life of a Showgirl. I'm positive Confessions of a Showgirl would have come up. It was a registered trademark in 2015. Now, this is costing a lot of money, and it's not a sure thing that she's going to win. Taylor Swift has spent a ton of money branding her Life of a Showgirl tour, and she might not even be able to use the name. That could have been solved by a USPTO trademark search. When we're talking about Elon Musk, we're talking about protecting minority shareholders. We're talking about not breaching your fiduciary duties. When we're talking about Elon Musk, we're talking about making sure you're papering your equity investments. When we're talking about Elon Musk, we're talking about the power of capital. We're talking about being able to build by having a clean cap table. That means you need to paper each of your equities. That means you need to paper each of the investments that comes into your company. You need to know what the fair market value is at each of your priced rounds. And you need to make sure that it's clean, because that's what's going to allow you to raise more money, access more capital, and do bigger projects. And finally, talking about AI, what do you own? You need to check your contracts. You need to make sure that if you're using AI content with AI, it's not the Wild West anymore with CNN versus Perplexity. Perplexity is sucking up data from all over the internet. And most of these AI platforms are doing that. And you're using that data too. Know what you own and know what you don't own. And when it comes to your own contracts and you're feeding data into a platform, or you're feeding data into a company, when you're feeding data into an AI platform, you need to know, what data are you offering up to its training models? What data do you no longer own anymore? We see this a lot with entertainment and actors who are now signing contracts and unknowingly giving away their name, image, and likeness in perpetuity. So today, AI is no longer the Wild West, but the contracts are a minefield. And when you're reviewing a contract and there's an AI company involved, you don't want to give up all your rights. You want to make sure you're licensing what you own. And if you're using AI data, you need to be clear about what you own and what you don't own. You need to be clear that your human expression is what you own, but the rest of it is really up for grabs right now.
Absolutely. So with that said, we are Letters of Intent. We appreciate you all joining us and spending your time with us. We know your time is valuable, and we hope this information is valuable. We are the law firm at Carbon Law Group for deal makers and risk takers. We are supporting entrepreneurs and growing companies scale quickly. Hopefully, if they're going to break things, do it in a way that doesn't cause you too much distress, and shoot for the stars. And if you're Elon Musk, maybe shoot for Mars. Until next time, we appreciate you joining us, and you can always like, follow, share for more. Please drop us a line in the comments if you want to hear more information on something specifically, or if you want to find out more about what we're doing or have any questions about your own business. We always love to hear from our listeners, and we thank you again for joining us.
And make sure you tune in next week, where we're going to size up the next 3 newsiest, hottest, buzziest deals and break down how they apply to you. Thank you for joining us on this episode of Letters of Intent, the podcast for deal makers and risk takers.